Sometimes you're just looking through the news and something completely unexpected jumps out. We've been digging into this really surprising legal situation, actually. Involves a law that, well, it feels ancient.
It really does. We're talking about the Supreme Court putting a temporary block on deporting some Venezuelan migrants. They're being held up in northern Texas.
Yeah, and our main source here is a really detailed Associated Press report that kind of walks through all the twists and turns.
It's pretty essential for understanding this, yeah.
So the headline itself, Supreme Court stops deportations, that gets your attention. But the really wild part, the whole thing hinges on the Alien Enemies Act.
Of 1798.
Exactly, 1798. I mean, just think about that. A law from the very early days of the U.S. suddenly right in the middle of today's immigration arguments.
It's quite something. It really shows how old laws can just pop back up, you know. This one was originally for, like, potential wartime situations with France.
A wartime measure.
Right. And the AP report, it does mention other big news, nuclear stuff, global tensions, all that.
Yeah, sure, context.
But this Supreme Court decision, this deportation block using this specific law, it's a major development, especially since the act was meant for, declared war or imminent invasion scenarios.
Not exactly what we have here.
Not really. Applying it because someone is allegedly in a gang, that's a pretty big stretch from its original intent. Raises a lot of questions about how it might be used, down the line.
Absolutely. So, okay, our mission for this deep dive is really to unpack this. What exactly did the court say? What's the deal with this super old law? And crucially, what does it mean right now for the people affected?
Let's start with the court's order itself.
Yeah, what were the specifics?
So the AP report lays it out. It's a brief order, but significant. It tells the Trump administration basically temporarily stop removing these Venezuelan migrants who are at the Bluebonnet Detention Center in North Texas.
Okay, temporarily.
Right, key word. It's effective until further order of this court.
So the story isn't finished.
Far from it. This is likely just, round one.
And the report mentioned it wasn't unanimous. Thomas and Alito dissented.
That's right. Justices Thomas and Alito disagreed with the temporary block.
Which, always makes you wonder about the different legal viewpoints. Any idea, based on their usual stances, why they might have dissented here?
Well, the report doesn't get into their specific reasoning in this brief order. But generally speaking, dissents like this often come down to differing views on the court's role in these kinds of emergency appeals.
Right.
And maybe how much deference courts should give the executive branch, especially on immigration or national security matters. They might have felt the lower court should have handled it first, perhaps.
Okay, makes sense. So the court stepped in for now, but the whole reason this is happening is this Alien Enemies Act of 1798. Let's dig into that. Why did the ACLU bring this to the Supreme Court so urgently?
Well, the ACLU filed that emergency appeal because they saw the administration appearing to restart deportations using this very old law.
Restarting them?
Yeah, or at least gearing up to. Their big worry, the report says, was people being removed really fast without, proper legal checks.
Due process.
Exactly. And the history here is pretty stark. The ACLU pointed out it's only really been used 3 times before, most famously during World War II.
The internment of Japanese Americans.
Right, which, using that historical context alone raises serious red flags about using it today in this situation.
Yeah, that parallel is uncomfortable, to say the least. So what was the administration's reason for dusting off this 18th century law?
Their argument, according to the AP, was that this act gave them the power they needed to quickly remove immigrants they'd identified as members of a gang, the Tren de Aragua gang.
Regardless of their immigration status.
Correct. They framed it as, a necessary national security move, removing people they saw as a threat quickly.
Okay, so national security, swift action, that's the administration's side. But the ACLU obviously saw it very differently. What were their main objections?
Due process, fundamentally. That's what the ACLU lawyer, Lee Gaylord, hammered home. He expressed huge relief at the temporary stop.
Yeah.
He said the fear was individuals being sent off to a brutal Salvadoran prison without ever having had any due process. That phrase, due process, it's about fairness, right? Understanding the accusations, having a chance to respond before something drastic like deportation happens.
And they filed a lawsuit.
They did. Specifically trying to stop 2 Venezuelan men at Bluebonnet from being deported, but also asking for a wider ban on, using the act in that whole region.
And the core issue was the administration labeling these men as gang members.
Yes, that was the trigger.
Yeah.
The ACLU warned that immigration authorities were basically accusing these Venezuelan men in bluebonnet of being part of Tren de Aragua. That was the justification for using the Alien Enemies Act.
But the ACLU questioned that.
They raised serious doubts. Doubts about the evidence, doubts about how fair the process was for even making that determination.
And there was that disturbing story from one lawyer about her client.
Yeah, that was quite concerning. The lawyer, Corrine Brown, described her client, who only speaks Spanish, being given legal papers in English.
And told to sign them.
Told to sign them, and reportedly told by ICE that he'd be deported whether he signed or not.
Wow. That raises huge questions about, well, basic fairness. Informed consent, language barriers.
Absolutely. It suggests a process that might be rushed, potentially coercive, and maybe not just at all.
Okay, so before the Supreme Court got involved, this went through lower courts, right? What happened there?
It did. The AP report says 2 federal judges initially refused to step in.
Refused.
Yeah, chose not to intervene. And then the 5th U.S. Circuit Court of Appeals also declined to issue any protective order. So the detainees weren't getting help from the lower courts before the Supreme Court acted.
There was one judge mentioned, James Wesley Hendricks, a Trump appointee.
Right, Judge Hendricks. He specifically declined to block the deportations for the 2 men named in the ACLU suit.
Yeah.
His reasoning, according to the report, was based on ICE filing statements saying those 2 specific men wouldn't be immediately deported. So he seemed focused on the immediate assurance for those 2.
But he wouldn't issue a broader order to protect others in the region?
Correct. He was reluctant to do that. Apparently, his view was that widespread removals hadn't actually started yet.
So a kind of wait-and-see approach.
Seems like it. Maybe he felt a broader order wasn't justified at that exact moment.
Okay, then things moved to a hearing in D.C. with Judge James Boasberg. What happened there?
Right, that was a Friday evening hearing. The ACLU lawyer, Gellert, argued that the administration was basically playing jurisdictional games.
How so?
He claimed, as the AP reported, that Venezuelans were first being processed down in South Texas. But then a judge there blocked deportations under the act. So Gellert argued the administration started moving them to Bluebonnet in North Texas, specifically to get around that first judge's order.
Trying to find a district where they could deport them under the act.
That was the ACLU's argument, yes.
Yeah.
Circumvention.
And Judge Boasberg's reaction?
He seemed sympathetic, according to the report, but he said he felt powerless to stop it.
Powerless? Why?
Because of a previous Supreme Court ruling. It essentially said that orders against deportation have to come from judges in the actual place, the jurisdiction where the immigrants are being held.
Jurisdiction again. Since the men were in North Texas, Boasberg in D.C. felt he couldn't issue an order for them there.
Exactly. It sounds like a frustrating procedural knot for the ACLU.
But Boasberg had looked at this before, hadn't he? Something about contempt?
Yes. Earlier that week, he'd found probable cause that the Trump administration might have committed criminal contempt.
On what grounds?
Based on the paperwork ICE was giving detainees. Boasberg felt it didn't clearly tell them they had a right to challenge their removal in court. He thought that lack of clear info might violate an earlier Supreme Court directive.
So concerns about proper notification. What did the Justice Department say to that?
Their lawyer, Drew Ensign, pushed back. He argued, according to the AP, that people would get at least 24 hours to challenge their removal.
Okay.
He did say no flights were scheduled for that Friday night, and he didn't know of any for Saturday. But, importantly, he also maintained the DHS still had the legal right to remove people during that time if they chose to.
So a bit of a mixed message there. It sounds like a really tangled legal situation across different courts.
Definitely. Lots of moving parts.
Now, the AP report also mentioned an earlier Supreme Court order from April 9th. How does that fit in?
That April 9th order was actually unanimous, and it's pretty key here. It basically established that before anyone could be deported under the Alien Enemies Act, there had to be some kind of process allowing them to make their case in court.
Setting a standard for due process under this act.
Precisely. And following that order, judges in Colorado, New York, and importantly Southern Texas, did issue orders blocking removals in their areas until that process was sorted out.
But not in Northern Texas where Bluebonnet is.
Exactly. That was the gap the ACLU was trying to close, which led to this latest Supreme Court intervention.
And the stakes are incredibly high for the people involved, right? The report mentioned where some might end up.
Yeah, that was a sobering detail. The AP reported that some Venezuelans who have been deported under this act were sent to El Salvador, and apparently they're being held in a notorious Maine prison.
That really underscores the human cost here. These aren't just abstract legal arguments.
Not at all. These decisions have potentially devastating, real-world consequences for the individuals, life-threatening even.
The report also touched on one other ruling, I think, in Massachusetts. Seemed unrelated, but maybe relevant contextually.
Yeah, it was separate from the Alien Enemies Act case. That Massachusetts judge made permanent a ban on deporting immigrants who've already lost their appeals to a different country, like a third country, unless two things happen.
Okay, what are they?
First, they have to be told where they're being sent. And second, they had to get a chance to object if they fear they'll be tortured or killed there.
So another layer of due process focused on the destination country.
Exactly. While it's a different legal issue, including it kind of highlights this broader theme in immigration law right now, pushing for more procedural safeguards and basic rights for people facing deportation, whatever the specific legal tool being used.
Okay, so let's try and wrap this up. The big picture is the Supreme Court has hit pause temporarily on these specific deportations from northern Texas.
Right, a temporary halt.
But it throws this incredibly old wartime law back into the spotlight in a modern immigration fight, and it really forces us to look at due process rights for people detained.
Absolutely. And like we said, it's temporary. The AP report notes everyone expects the Trump administration to go back to the Supreme Court very quickly, asking them to lift this block.
So the legal fight continues.
Definitely ongoing. This isn't settled yet.
It really does feel like a significant case to watch. So maybe a final thought for our listeners to chew on. What does it really mean long-term to pull out a law written in 1798 for a totally different world and apply it to today's immigration situation? And maybe what does this whole episode tell us about how we're balancing or maybe struggling to balance national security concerns with, the fundamental rights of individuals, regardless of where they come from? It's worth thinking about that history, 1798, and what it means to use that tool today.